Dear colleagues, we are pleased to present a new video on the Congar Law Firm YouTube channel. Shipbuilding is a monumental undertaking, blending heavy industry, advanced engineering, and major financial investment. Behind every vessel lies a complex legal framework, shipbuilding law. This specialized area of maritime law governs the agreements to construct and deliver ships. Without clear legal rules, the risks in building a ship would be unmanageable. Multiple parties, huge sums and long timelines demand a solid legal foundation. Shipbuilding law assures ship owners their vessel will be built to specification, delivered on time, and perform as expected. For builders, it guarantees payment and protection from unreasonable demands. Financiers and insurers rely on this law for security in backing such capital-intensive projects. The contract is the architectural plan for the entire legal and commercial relationship. It must anticipate problems over years of construction, from technical failures to global economic shifts. Shipbuilding law provides tools to draft contracts that withstand these pressures. We'll explore the core components of shipbuilding law, essential contract elements and common clauses. We'll discuss typical disputes and their resolution, plus the roles of insurance and international regulations. By the end, you'll understand the legal principles underpinning the global shipbuilding industry. This knowledge is vital for anyone involved in this dynamic sector. Let's chart the legal waters of shipbuilding. A shipbuilding contract is the cornerstone of any vessel construction project. It's a detailed legal agreement between a buyer and a builder, outlining every aspect from design to delivery. The contract specifies technical details, price, payment schedule, delivery date, and required standards. The shipbuilder must construct the vessel to agreed specifications and deliver it on time. The buyer pays in installments linked to construction milestones. Classification is critical. Ships must meet standards set by recognized societies like Lloyd's Register. The builder must obtain a certificate confirming compliance, essential for insurance and international trade. The contract also defines when ownership transfers, either in stages or upon final payment and delivery. This is crucial if financial difficulties arise during construction. The contract must address what happens if the project fails, including rights to materials and the partially built hull. In essence, the contract is the legal backbone of the entire shipbuilding process. Every detail matters. Several key clauses define the shipbuilding contract. The delivery clause sets a firm date for completion. Delays trigger liquidated damages unless excused by force majeure. The warranty clause protects the buyer after delivery, requiring the builder to fix defects for a set period. Dispute resolution and governing law clauses determine how and where disagreements are settled. Arbitration is common, often under English law. The termination clause allows either party to exit if the other defaults, protecting against excessive delays, insolvency, or non-payment. These clauses allocate risk, define remedies, and keep the project on track. A well-drafted contract anticipates problems and provides clear solutions. Each clause is a safeguard for both sides. Together they form the legal engine that drives the project forward. Without them, shipbuilding would be chaos. Precision in drafting is everything. Even with detailed contracts, disputes are common in shipbuilding. Delivery delays are a frequent flashpoint. Owners need ships operational on time, while builders may cite force majeure. Disputes often hinge on interpreting delay clauses and the evidence behind them. Defects and quality standards are another battleground. Buyers may reject delivery, claiming non-conformity, while builders insist on compliance. These issues require technical experts and often involve extensive testing. Payment disputes arise over modifications and change orders. Was it within scope, or does it require extra payment? Builders may halt work until prices are agreed. Buyers may dispute costs, leading to deadlock. Most disputes are resolved through arbitration, which is faster and more private than court. Arbitrators with maritime expertise ensure informed decisions. The process is document-heavy, with expert reports and witness statements. The arbitral award is final and enforceable worldwide. This system keeps even the most complex projects afloat. Managing risk is paramount in shipbuilding. The contract allocates risk. Typically, the builder bears it until delivery. Builder's risk insurance covers loss or damage during construction, protecting both builder and buyer. The buyer is named as co-insured, safeguarding their installment payments. At delivery, risk shifts to the buyer, who must have operational insurance ready. The handover is carefully timed to avoid insurance gaps. Financial risks are also managed. Buyers require refund guarantees from banks in case the builder defaults. Builders retain title until full payment, protecting against buyer default. These mechanisms ensure both sides are protected throughout the project. Insurance and guarantees are non-negotiable safeguards. Without them, the financial stakes would be too high. Risk management is the backbone of every shipbuilding deal. Shipbuilding is shaped by international rules and standards. The contract mandates compliance with conventions set by the International Maritime Organization, IMO, covering safety, security, and pollution prevention. Key IMO conventions include SOLAS for safety and MARPOL for pollution control. The builder must ensure the vessel is certified as compliant at delivery. Non-compliance means the ship can't trade. Classification societies set technical standards. The contract requires the vessel to be in class. Compliance is essential for insurance and flag state approval. Export controls and anti-corruption laws also impact contracts, restricting certain technologies and mandating ethical conduct. Clauses requiring compliance with these laws are now standard. International standards ensure ships are safe, legal, and insurable. Global rules are embedded in every contract. For ship owners, careful planning is crucial. Technical specifications must be complete and clear. Ambiguity leads to disputes. Payment schedules should match construction milestones, and refund guarantees from top banks are essential. Legal counsel must review guarantee wording to ensure full protection. Owners should monitor construction closely, with site access and regular progress reports. Early detection of issues saves time and money. Delivery and acceptance procedures must be understood. Sea trials verify performance. Owners shouldn't accept a vessel that fails to meet requirements. The protocol of delivery and acceptance is legally binding. Signing it limits future claims. Vigilance at every stage protects the owner's investment. Preparation is the key to a successful build. For builders, success starts with understanding the contract and technical specs. Clarify any ambiguities before signing. Unclear requirements lead to disputes. Manage delays and change orders by keeping detailed records and following notice procedures. Use the formal change order process for buyer requests to secure extra time and payment. Lawyers should draft clear, balanced contracts, using industry forms as a base but tailoring them to the project. Focus on what-if scenarios, default, delay, defect, and provide clear solutions. Ensure clients understand dispute resolution options and the implications of governing law. Legal advice continues throughout construction, helping manage issues and prevent escalation. Proactive management and legal support keep projects on track. Builders must protect their interests from day one. Clarity and diligence are the builder's best tools. Shipbuilding law is the essential framework that makes these massive projects possible. It brings order and predictability to a high-risk, multi-year process. By defining rights and obligations, it allows parties to manage risk and keep projects on course. The contract governs everything: specs, payments, delivery, and dispute resolution. International regulations and classification standards ensure ships are safe and legal worldwide. Insurance and guarantees provide financial stability. For ship owners, builders, lawyers, and financiers, understanding shipbuilding law is a practical necessity. It's the foundation for global trade and maritime innovation. The world's fleet is built on steel and on solid legal ground. Shipbuilding law keeps the industry afloat. Thank you for watching our video. Please remember to follow, like, and share the Congar YouTube page for more information. I hope you all have a pleasant day.